Hi, everybody. It's Ronelle Delmont again. I made a video a few days ago on the anniversary of the 125th birthday of Richard Hauptmann. I got a few things wrong in that video, such as the year he was born, thanks to Sue Campbell, who emailed me immediately saying, "You got the date wrong. It's not 1895. He was born in 1899. And that would have made him 125 years. Okay, I sort of corrected it. But I did say that I was going to read the objections that his lawyer at his trial in Flemington, New Jersey, from January to February 1935, Hauptmann was put on trial. His lawyer was the fellow you see with the glasses on the right. The picture you're looking at there, of course, is the famous or infamous Jaffe, Dr. John Francis Condon. This is the cover of a Liberty magazine story. Liberty magazine is fantastic to research the case. I believe they're all available for free online in an archive somewhere. Liberty magazine. I don't remember when they went out of business, but they published all the articles on the trial, on the kidnapping, and this is a famous cover with John Francis Condon, otherwise known as Jaffe. JFC were his initials, so he called himself Jaffe to do business with the supposed, in the negotiations with the supposed kidnappers and cemeteries and all of that. But I'm here to read to you Lloyd Fisher's arguments. I couldn't remember the title in my previous video. It's called Various Things Done by the Prosecution to Hinder and Hold Up the Defense. In other words, sabotage the defense. And in parentheses, he's got things never before done, so far as I know. He was a New Jersey lawyer who actually defended in the first trial of the Lindbergh kidnapping scenario. There was an earlier trial with John Hughes Curtis, and I made a video interviewing Jim Davidson, who wrote a book about it. I'm trying to be informative to people who don't know a thing about this case, but it's difficult. But anyway, I'm going to read to you his five objections. I don't know where the rest of it is. It looks like there's more to it. Actually, there are 8 objections. And he did write a memoir that never got published. I have a copy of that, but it's very long. It's almost 200 pages. Okay, so what was his objection? What did he have to say after? And I'm not sure when this was done, whether Hauptmann had already been electrocuted or not. But here we go. Number 1, the state was procuring an up-to-the-minute copy of the record. They were using the stenotype system, and complete copies of the testimony up to within 15 minutes of any given point in the testimony was available. The cost of this was tremendous, amounting to over $24,000. John Van Blorum and the man with the stenotype contract called me one day and told me that they were willing to give me a copy of the testimony since they knew I couldn't pay for it. You know, that the state took all of Hauptmann's money away, and he had no money to defend him. Okay, it was going to cost $24,000. They were going to give him a free copy. I couldn't pay for it. The thought, of course, that with the transcript before us, we would be able to stretch out the cross-examination and thus run up the testimony. Having a copy of the transcript would have enabled him to run up the testimony, to be more effective in their own defense, and there would be more pages of it. And they were being paid on a page basis, despite the fact that it would not have cost the prosecution one penny, and despite the fact that the prosecution themselves had this service, Willens refused to permit Van Blorum to give me a copy. So they were conducting a trial, a defense for Richard Hauptmann. They had no copy of the testimony, of the transcript, as the prosecution automatically did at no cost. Okay, number 2, examination of handwriting exhibits. We were never permitted an adequate opportunity to examine the ransom notes or other handwriting exhibits. The one and only time that our side of the case, either counsel or experts, were permitted to see the notes. He's talking about the ransom notes. There were, 14 of them? The one and only time our side were permitted to see the notes was for a single half day in the Hotel Hildebrecht. Was it Hildebrecht? I think he got it wrong. I think it's the Hildebrand, but whatever. In the Hotel Hildebrecht, when the notes were brought to a suite in the Hildebrecht, and accompanying the notes were Joe Lanigan, Bob Peacock, Lieutenant Snook of the State Police, Hausling of the State Police. I think one of the state's handwriting experts, although I am not quite sure about that, and 2 or 3 more state representatives. They stayed in the room with our experts who were examining the notes. Our experts were not permitted to have copies of the notes. And so far as an opportunity to compare was concerned, or to study them, there wasn't any. This is contrary to all accepted practice. In law, this was ridiculous even in 1935. That's his point here. He said up at the top, things never done so far as I know. Yeah. You know, I never read anything to an audience. I've been doing lectures for 30 years. I never do this because I've watched other lecturers, other speakers read from papers, and everyone in the audience is going, oh. They're all asleep. They're all asleep. So I'm not putting you to sleep. You can rewind this and listen to it. If you're listening as a podcast, you can hear it. I hope you're not going to sleep because I'm reading from papers. I never do this. I don't read to people. I'm not a reader. I'm just a storyteller. Okay, number 3. Next, it was impossible for counsel to have a fair conference with Hauptmann. At no time during his incarceration in the Flemington jail was there ever a single occasion when I could sit down and talk with this man out of earshot of a policeman. Really? The policeman was sitting with him while he talked to his lawyer? Really? I repeatedly asked them to withdraw, and they would go no further than a door and more than 20 feet away, and refused to close the door. Even whispers could be overheard by these policemen. I was obliged, in connection with many important questions I wanted to ask Hauptmann, anything that I wanted to keep secret, to resort to writing the question on a pad while I talked about something else. And then he, in turn, would write the answer. There was some talk that there was a dictaphone in the immediate vicinity of Hauptmann's cell. They were recording him. And one person who claimed to know always insisted that there was one there in a small lunchbox. I never saw it and have never believed there was any there. John Curtis, the sheriff, that's not the same John Curtis that went on trial for the hoax against Lindbergh. Jim Davidson wrote that book about it. John Curtis, the sheriff, would of necessity know if there had been any wires in the cell. And he has sworn to me on a number of occasions that there wasn't. And I personally would have noticed the lunchbox if it had been there because I always kept a sharp lookout. Okay. Now, which number is this? Number 4. The refusal to permit defense to view physical features of the case. For instance, letter A, part A. The refusal to permit an examination of the Hauptmann home. I repeatedly sought this permission, and on one occasion, Wilentz agreed. This is David Wilentz, Attorney General, never did a crime, never defended or never prosecuted any criminal, never prosecuted a murder case, for sure, he never did. Okay. I repeatedly sought permission. On one occasion, Wilentz agreed that I should get in. I went to New York with Sam Bodine and John Schenck, one a lumberman and the other a foundry man, whom I thought might, by their very appearance, impress the jury. The state police in charge of the house would not let me in. So he doesn't explain here. Louis Bornman, the Lieutenant Bornman, rented the house in his own name after Anna Hauptmann was distraught over her husband's arrest and imprisonment, and she couldn't live in the apartment anymore. They didn't own the house, by the way. They rented the upstairs apartment from Mrs. Pauline Rausch was her name, who lived below. And Anna Hauptmann and her little boy Manfred could not, the police made it impossible for them to remain there. So Anna left and went to live with relatives, and Louis Bornman, Detective Lieutenant Bornman, lived in the house under, I believe he rented it under his own name, but on behalf of the New Jersey police. He lived there and had, what can I say? He would not permit anybody he didn't like to come in. I repeatedly sought this permission. On one occasion, Wilentz agreed that I should get in. I went to New York with Bodine and Schenck, one a lumberman and the other a foundry man, whom I thought might by their very appearance impress the jury. The state police in charge of the house would not let me in. I called Schwarzkopf and Wilentz, and they kept passing the buck all day, and I never got in. There's, in his memoir, he goes into much detail about this predicament. Between Schwarzkopf and Wilentz, they were playing a game, both of them promising that he could get in with his experts, and they delayed and delayed. The things that they did, it's not explained in this, but in his memoir, it's so aggravating, you want to rip up the book. Okay, I called Schwarzkopf and Wilentz. They kept passing the buck all day, and I never got in. The first time I tried to call Wilentz, someone at his house answered that he was sick in bed with tonsillitis and couldn't talk. I threatened to call the press. I threatened to call the press and tell them the whole story. And then he very promptly appeared at the phone. And in a voice as strong as mine, started to make excuses. The next week, Wilentz agreed with me that before he left on Friday, he would give me a written authorization to go in the house the next day. And they're talking about Hauptmann's house. That night, he left immediately at the conclusion of the testimony. I was unable to see him, and I couldn't contact him at all that evening. So he's got a note here concerning the Lindbergh property. So I don't want you to be confused. That he's aggravated because the wood in the ladder supposedly comes from that attic in the Bronx house, and they wouldn't let him in. Now he's got a note, Part B, the refusal to permit defense to visit the Lindbergh house and surrounding territory. I made application to Schwarzkopf for permission to visit the Lindbergh house a number of times, both before and during the trial here, but never got that permission. After the trial, and while the appeal was pending, I again made application to Schwarzkopf. He then advised me that the property had been turned over to an organization. Some of you already know that Lindbergh and his wife, I'm not even sure who owned the property. I think it was in Ann's name, but whatever. They turned it over to the state of New Jersey. Originally, Lindbergh was making a laboratory for Alexis Carrel, his mentor, Alexis Carrel. And they were going, he got a bunch of guys. I could talk about that at another time. Lindbergh was trying to raise money. I don't know why. He was a millionaire. His wife was linked to billionaires. They were looking for other people to foot the bill for his estate, his home in Hopewell, as a laboratory for the other eugenic cuckoo lunatic, Alexis Carrel, who was going to end up dead in Paris, a Nazi collaborator with the Vichy government. Lindbergh, anyway, so that's what was happening to the Hopewell house in the summer. It was around Anne's birthday, June 22nd, 23rd, in 1934, that is designated, it's documented that that's the first time we hear that the house is going, she wrote in her book, A Letter to Her Mother, that the house is going to be used for young boys. And so if that happened in June of 34, the trial is in January, February 35. So it is true that the house was turned over to the state of New Jersey. It's not going to be used until the 40s. I don't even understand what went on there from June of 34, and they set up a trust with Schwartz. The people on the trust were her mother, herself, Charles Lindbergh, Henry Breckenridge, the lawyer, the guy, I forget the first names of the two brothers, one with the Rockefeller Institute, the other one at Princeton. They were Flexner. I forget which Flexner it was that was going to be on the board of this home that they were giving away to the state of New Jersey for the purpose of helping young boys. That's another story. Okay, where was I? So he's complaining, getting lost here. Yeah. I made an application to Schwarzkopf. He then advised me that the property had been turned over to an organization and that the state police and the Lindberghs had nothing to do with it, and was awfully sorry that he couldn't give me permission. Schwarzkopf couldn't give him permission. The chief of police of the state of New Jersey couldn't. Okay, I assumed from that I could just drive up there and go in, at least on the grounds. It's 400 acres. I did drive there, and to my amazement, there were two state policemen on duty at the end of the lane. There was a sign, State Police Substation. Apparently, Schwarzkopf had deliberately lied to me. I have never yet visited the Lindbergh home, inside or outside. Okay, number 5, the matter of crowding the prosecution table with notables. For example, General Ryan, Breckinridge, Lindbergh himself, ex-Attorney General Stevens, and any other influential and well-known people whose presence at the table necessarily could well imply a sympathy with the state's case. I have never known that to occur before in the trial of any criminal case. Although Lindbergh testified less than an hour, amazing, less than an hour. Actually, well, maybe combined, it was less than an hour. He was at the state's table every single hour of the trial. The crowded condition of the courtroom by people admitted on subpoena signed by Willents, and the special passes he had engraved. Let's not forget, he's becoming a rock star from this trial. David Willents, the rock star. That's why I spoke about the Huntington Democrat, yes, in the last video that I made. I was kind of half asleep while I was speaking because I'd just come off a ship from the Caribbean, and I was doing it at 5:30 in the morning. But I think you might have gotten the point that I was trying the connection I was trying to show you between good journalism and biased journalism and journalism that's not free speech. Because, okay, we'll get back to that some other time. Okay, where am I? Although Lindbergh testified less than an hour, he was at the state's table every single hour of the trial. The crowd, and that's interesting because when I had a forum for many years attached to my website, and every day people like myself who were interested, we spend hours and hours, practically too much of our lives, arguing with each other. And one of the big arguments that went on back then is this question of, did Lindbergh really sit at the prosecution table? Everybody was saying, no, you get the wrong trial. It's a different trial. It's a different picture. They're pictures that are very hard to discern where Lindbergh was actually sitting at Hauptmann's trial. It's so crowded, and he looks like he's he's sitting in a row of chairs behind. He was always behind the prosecution desk, and according to Lloyd Fisher, maybe I didn't tell you the name of the guy that's writing this. Lloyd Fisher was the New Jersey lawyer that had to take a back seat to this guy over here with the glasses. That's the attorney that from Brooklyn, the guy with the glasses in the picture behind me. That's Edward Riley. He was hired by Hearst for the scoop that Hearst needed for his headlines, and Hearst paid, I don't remember the amount, he paid Ed Riley a certain amount of money to defend Hauptmann, and Anna Hauptmann had no money. They actually had a very good lawyer, and he could have been defended by a good lawyer instead of this man who is going to die in an insane asylum in a couple of years, who had syphilis. And that's what he was suffering from in the last years of his life. Ed Riley. Where was I going? No, I forgot the reason I brought it up. Anyway, yes, Lloyd Fisher would have been, Lloyd Fisher really believed in Hauptmann's innocence. He was outraged by the way Riley was conducting the defense. And at one point, I think many of you know what that was about. It's a very famous moment in the trial where Lloyd Fisher actually stormed out of the courthouse because Ed Riley openly said, without challenging any of it, that the body that was found in the woods, we believe, he said, the defense believes that was Lindbergh's son, when they could have had the trial at an end if a good attorney had been able, and Ed Riley obviously I think he must have purposely sabotaged Hauptmann's case. He never even spoke to Hauptmann, hardly ever. And now he's admitting, without being challenged, without even being asked, he just came out one day and said, Your Honor, we do not challenge the identity of that corpse. It is the Lindbergh. Now, nobody could recognize it. Lindbergh said it was his. Betty Gauss said she recognized the shirt. I do believe it was the child, but they could have had, what do you call it? In the trial. And anyway, okay, get back. He didn't have to admit that that was the child. They could have gone on making a case for why it might have been another baby that was found there, because it was unrecognizable. Okay. The matter of crowding the prosecution. He was at the state's table every single hour of the trial. There were so many people who objected to this when I had my forum. People wrote over and over saying, You're crazy. He never sat at, and the reason people got bent out of shape over that is because it's obviously ridiculous. You cannot defend that. That's not defensible. There's no reason for the father of the dead baby to be sitting at the prosecution table. So people got really upset. And here is Lloyd Fisher saying, yes, that is exactly what happened. So those of you who were involved with my forum, who kept complaining that this is not true, we're making stuff up, here it is, black and white, right here. The crowded condition of the courtroom by people admitted on subpoena, signed by Willens, and the special passes he had engraved. Like I say, he became a rock star from this trial. He was the Pope of Perth Amboy or South Amboy, whatever they call it, and heavily connected with the Democratic Party, with the Hunterdon Democrat newspaper. That's where I stopped and I got off on a tangent. We had agreed with Justice Trenchard not to continue the practice of passing out subpoenas. They had an effect of increasing what already was a very sympathetic audience so far as the state was concerned. Through the years, I have learned, so he wrote this many years later, or through the years, I have learned that the attitude of an audience in the courtroom impresses a jury more or less, and that an exceedingly sympathetic audience indicates a verdict in favor of the side the crowd sympathizes with. I have always considered this a very vital factor in the case. So he's accusing Judge Trenchard of not controlling the audience. Obviously, the guy didn't, because when he went to sum up the case for the jury, he kept saying, Do you believe this? Do you believe this? Do you believe? It wasn't, when you read the transcript, and even Charles Lindbergh pointed this out, because he was there every day. Judge Trenchard gave the jury a background of what their charges were. And he went over the testimony, and every time he got to something of the defense, he said, Now, do you believe that? Do you believe that? Judge Trenchmouth is what I call him. Judge Trenchmouth. Well, what's left? Okay, number 7, the unlimited expenditure of money by the state, as opposed to no money on behalf of the defense. For example, the payment of over $33,000 for handwriting experts alone, where the defense had no money for that purpose. $33,000 for handwriting experts. No money for Hauptmann's handwriting experts. The refusal of the state to print the record on appeal. It was agreed by the state through Willens that this should be done, and an order had been presented to the court. When Willentz found out that a couple of dollars were being contributed to the defense fund, he raised particular hell, and we had to pay for the printing of the records, something like $6,000. Money which could have been spent in investigation. Likewise, Willentz tried, like the very devil, to get us to pay for the stenographic copy of the record which had been furnished us under the court's order. At the conclusion of the trial, before they knew there would be any defense money available. I have never known of a case where an order has been made directing the state to bear the costs in an instance like this, and that order later being rescinded. And the last one he's got here, number 8, the use of, at times, 6 assistant attorney generals, and on top of that, the employment of George K. Large of Flemington at a price of $8,000. Numerous other things, which for the moment have escaped my mind, were done by the state in what I consider a highly unethical manner, and which did much to prevent a proper preparation and trial of the case. There you got the short story. The long one is very, I guess I could put it up somewhere in a PDF. I'm not sure I have it in a PDF document, but he wrote a memoir, and that's C. Lloyd Fisher. The guy behind me there is Jaffe, and I'm one of the people who, if you're curious about what I think about Jaffe, I've gone around the block in ideas, theories, ideas. Everybody goes crazy over Jaffe. He's one of the keys to the whole case, because we all wonder, how did he get involved? Why did he get involved? Is there anything nefarious about his intentions? Was he there before the case, before the kidnapping, supposed kidnapping? Was he involved in the plot? Was he involved in it's very hard to pin him down, because he changed his story every 2 seconds. He didn't even remember what he said the day before, probably. And I'm one of the people who've come to believe that he was not involved in the actual death of the baby, or any plot involving the disappearance and the death of the child. I don't think so. I've made up my mind. He's an innocent patsy, and he's a patsy. That's what I think. Okay. I figured out where the record button is, and I hope to be talking to you again very soon. Happy holidays. If I don't make another video before then, enjoy your holidays, everybody. Bye.